Okay, we're now going to actually look at the terminology in the legal system. Many of the terms we've gone over before, but there's also quite a few that you've not been exposed to yet. I've indicated in several places that with the glossary of legal terms, you really need to listen to this recording because I give examples of particular terms, but also I will provide you with a printable version of the glossary, and you should print that out not only for this course, but for your comprehensive exam at the end of your classes in the HIT program, and also for your RHIT exam. It's a really good resource to review all the legal terms. To access your glossary, I've put a link on the home page. You'll click on that link on the home page and you'll see glossary of legal terms, and also you will see the printable version. I'm going to go over these terms again and give you examples, but after you view the recording, and you can use this glossary at any time during the semester as a resource to look up the definition of a term, but also again remember to print the version of the glossary in order to keep it. So let's start out with our glossary of legal terms, and we're going to go through the alphabet. And as I said, I'm not going to pay as much attention to those words or terms that we've already covered in depth, but there's some in here that you will see that you've not seen before. But I will review those that we have already covered. Now you'll see, let me start with the glossary, that you can go to, when you open the glossary itself, you can click on the letter of the alphabet and it'll take you directly to that area. And so we're going to start with the A's. The first term is admissibility. We've already talked about that. Admissibility is the worthiness of evidence that meets the legal rules of evidence and will be allowed to be presented to the jury. So something that can be by law, because there are rules of admissibility that are laws, but those things that can be shown to the jury or presented, that means that that particular thing, whether it's a document or whatever, that if it meets those rules, those legal rules, it can be shown to the jury, and that's known as admissibility. Advance directive, we've already talked about that. Just written instructions such as a living will, power of attorney for health care that recognized under state law and relating to the provision of medical care when the individual is incapacitated. And so advance directive, telling or directing in advance what you as an individual would like done if you are not capable of making the decisions yourself. And we're speaking here of health care. And so the living will is where you write down in advance exactly what you want or don't want. But the durable power of attorney is turning over that responsibility to someone else to make the decisions at the time. An affidavit. This is a written statement sworn to before a person who is legally permitted to administer an oath. Many times maybe you've had something notarized. Well, the notary public is authorized and is subscribing to the fact that you are the person signing a particular form, that you've shown ID, that is indeed you signing the form, and we'll put the seal on there and attest to that fact. So a written sworn statement. So you are swearing that you're that individual when you have something notarized. Allegation. An allegation is a statement that a person expects to be able to prove. I allege that the defendant did hereby on this date do this, that, and the other. That's an allegation. And so you hear that a lot of times in opening arguments in a trial, and one attorney will allege something. Doesn't mean it's truth at that point, but the allegation is basically a statement that someone says they will be able to prove. Arbitration. Arbitration is a process in which disputes are submitted to a third party or panel of experts outside of the judicial system. If there's any type of conflict, many times, nowadays especially, that will be sent through arbitration, or that a third party will make a decision rather than it going through the court systems. And you'll see this happen sometimes in the workplace, sometimes other situations that you enter into, and you say that you will abide by arbitration decisions if that comes to pass. And so arbitration is just a decision by a third party or a panel, but it's not the court system. Assault. Now, we've already talked about assault, an intentional act which is designed to make someone fearful and which provokes reasonable apprehension of harm. And we're going to talk about battery. Again, we've already talked about the two. Assault is making someone fearful that you are going to hurt them. And when I say that, and I'm using you, I'm not necessarily accusing you of assault. I'm just saying that assault is an intentional act to make the other person fearful of harm. Authentication, and we've talked about that a lot in every class basically. It's proof of authorship, whether someone signs their name to say, yes, I'm the author of this information, the rubber stamp, a computer key, electronic code. The next is authorization. Again, another very familiar term at this point in time. And it is the act of giving the right or the authority to act. So if we have an authorization for release of information that's been signed by the patient, that gives us the authority to release copies or release particular information on a patient, because the patient has signed a statement giving us that right to do that. We talked about auto-authentication, meaning authentication by computer code prior to transcription. Said this was a big no-no, that Joint Commission doesn't like it and Medicare doesn't accept it, that the physician should review a document prior to authenticating it rather than just dictating it and then authenticating it before it's ever typed up. So basically doing it automatically before review. Battery is the touching of one person by another without permission, usually the harmful or offensive touching of another person without permission. Battery. So with battery doesn't necessarily mean that someone is hauled off and hit somebody else. It doesn't even, but that can be the case. It can be the touching in any shape, form, or fashion that's offensive and has not been given done with permission of the other person. So remember, assault, battery, we normally hear those terms a lot of times together. Assault is making one fearful of harm, and battery is the actual touching or harmful or offensive touching. The best evidence rule. It's the legal doctrine requiring that primary evidence of a fact be introduced or at least explained before a copy can be introduced or testimony given concerning the fact. For example, best evidence if you have medical records or health records that are going to court. The best evidence would be the original medical record. Now we have a law on the books stating that a certified copy of the record is just as good as the original, but many times we're required to go to court, and at least if we're submitting a copy, to certify or testify to the fact that these records are copies of the originals and that they were made in the normal course of business. So the best evidence rule is to say you need the original before a copy can be introduced, or testimony given pertaining to that fact. Business records, we've talked about this many times. It's documents that are kept in the regular course of business. And medical records may be admissible because they're business records, not because they're medical records, but because they're business records. And if we keep those in the normal course of business at a healthcare institution or facility, whether it's outpatient or inpatient, if we normally keep a record on everybody in the normal course of business, then that's a business record. Bylaws. Bylaws are rules for running a corporation, business, or society. Usually you hear the term the medical staff bylaws. Those are basically the policies of the medical staff. So these are just the rules. They're the same thing as policies, but many times you'll hear the term bylaws. Case law, we've talked about that. That's unwritten law. Another name is judge-made law or common law. Civil law is the portion of the American law that does not deal with crimes. So if a injury or a tort has been committed to another person, then civil law is between two individuals or an individual and a corporation, but it's not criminal acts. A code is a written law. So a published set of written laws, usually arranged according to some numerical system or subdivision. Code. Many times I've mentioned the Code of Federal Regulations. Well, the Code of Federal Regulations is that published set of written federal laws. Common law, we just mentioned that when we say case law. The legal traditions of England and the U.S. where part of the law is developed by means of court decisions, also known as unwritten law or judge-made law, and so decisions are made on previous decisions. A complaint. A complaint is a written statement that begins a civil lawsuit in which the plaintiff details the claims against the defendant. So that starts the court proceedings where a complaint is filed, and it is a written statement. They say in a civil case, remember civil is between two individuals, or it can be an individual and a corporation, but it spells out exactly what the wrong was done, what that was. So it details the claims that the one who is suing or the plaintiff is making. Consent, a voluntary act by which one person agrees to allow someone else to do something. So consent, we've talked about that many times in the different types of consent. Corporate negligence. It's liability or being able to be held accountable, or the accountability of an organization for its own dependent acts of negligence. It imposes responsibility for monitoring the activities of independent and non-employed individuals functioning within its facility, such as the medical staff. So, corporate negligence is when a corporation or company is held liable for the acts of its independent contractors. We're going to talk, and we have already mentioned, respondeat superior, which is when a company or corporation is held responsible for the actions of its employees. Well, this is the same thing, except for corporate negligence, it's when there's independent contractors and the corporation is responsible for the acts of those independent contractors, not the employees of the facility or the corporation. And again, medical staff members are normally not employees of a hospital. They are independent contractors who bring patients to the hospital, who use the hospital, but they don't work for the hospital. So if a corporation such as a hospital was held liable for the acts of the medical staff members, that would be, or for the negligent acts of medical staff members, that's corporate negligence. A court order is a written or oral command or direction given by a judge. And so that can be orally from the bench. If the judge says do something, that's a court order, and it will be recorded by that court reporter and in the permanent record. But many times in health information, we will receive a document known as a court order telling us to do certain things. We've covered the fact that we have to have, in addition to the subpoena, we have to have a court order for certain health records, such as alcohol and drug rehab records. Federal law states that a subpoena is not good enough. We have to have a court order, and so it's signed by the judge, and it's usually going to be in the written form, but any order given by a judge is a court order. Criminal law, the division of the law that deals with crime and punishment. So where we had civil law, and that's when there's not crimes involved in it, that it's one individual suing another, but we have criminal laws, and these are the people that break the law and have committed a crime, or it deals with those individuals. Decedent, you see that's just the legal name for a deceased person, is the decedent. We've talked about defamation. It's the injury of a person's reputation or character by willful or malicious statements made to a third party. It includes both libel and slander. So those two collectively are defamation, libel and slander. Remember, we said slander. This is the way I remember it. Slander is to do with oral defamation, meaning speaking. Speaking and slander both start with an S, so it's just my way of remembering the difference between libel and slander. A defendant in a criminal case is the person accused of committing a crime. In a civil case or a civil suit, it's the party against whom the suit is brought. So we have the plaintiff, the defendant. We went over that. So the one who is getting sued basically is the defendant. A deposition. Deposition is a sworn statement of a witness made out of court, which may be admitted into evidence if it is impossible for the witness to attend in person. In health information, I have been at depositions that an attorney and a court reporter will show up, and they want to take a deposition about the health records, and rather than us going to, or the director of the department going to court and swearing to the fact that these records are indeed John Smith's records, they were made in the normal course of business, and these are true and full copy, then sometimes, once in a blue moon, not very often, but a deposition is taken, and that's exactly the same thing. But a court reporter has to be there, and you're sworn in, but that does not happen very often. But depositions are taken all the time in court proceedings, not necessarily about health information, but someone can be required to give a deposition, and they're sworn in, and they make statements out of court, but these are used as evidence in court. Discovery, we talked about that in length, just those pre-trial things that happen before the trial, those activities of the lawyers or the attorneys to determine what evidence the opposing side will present if the case comes to trial. So discovery, pre-trial activities. The doctrine of charitable immunity. This is a doctrine That said, not-for-profit hospitals were held by courts to be immune from liability for negligent conduct of the employees of a particular organization. It was overturned by a case known as Darling versus Charleston Community Hospital. But in the past, and this is now in the pretty long ago past, but this is a very important case because it did do away with the doctrine of charitable immunity. It said if you go to a nonprofit hospital, then you don't have the right to sue for negligence or for negligent conduct. So there was an individual by the name Darling, a patient, who actually lost a limb because of the circulation in his leg being cut off by a cast, and in the documentation it was noted in the record that the doctor had ordered that the nurses should check the circulation in the feet and document that, and it was not documented. The word was it was done, but we just didn't document that we checked it because it was normal. And so that case overturned the doctrine of charitable immunity, and Mr. Darling did in fact sue Charleston Community Hospital. Ducis tecum, we've talked about subpoena ducis tecum, but just the term ducis tecum means to bring with you. In a minute, in the glossary, we'll see subpoena ducis tecum. We've already covered that. That means come and bring the records with you. But the ducis tecum part of it means bring with you. Subpoena means to come to court. Durable power of attorney. Durable power of attorney is, we've talked about that, one type of advance directive that empowers an individual to make personal health care related decisions for another person in the event that that person is incapacitated. Durable power of attorney, and it will be specific. There's power of attorney, and you can turn over the right to make legal decisions to another individual for any circumstance, but durable power of attorney for medical purposes, that limits it. That limits that person's power to make decisions. Okay, an emancipated minor. We've talked about an emancipated minor before. This is a minor who is married or otherwise no longer subject to parental control and who is not supported by his parents. We talked about an individual, for example, who is a minor, is underage in a particular state, and either got married or actually went through the legal proceedings to, and I use this term in quotes, to divorce the parents, meaning parents no longer have control of this minor, so this minor can make his or her own decisions, and this comes from the court to say this minor is now emancipated. That minor is no longer under parental control. We also talked about a mature minor. And a minor is mature only in certain circumstances. And the example that I gave you before, the age of majority in the state of Alabama is 19 years of age. But at 14, a minor is mature to make decisions about health care. So they're only mature in a particular in just particular circumstances. But emancipated minor, that minor has gone through the system or has married or gone through the system and basically divorced his or her parents. Expert witness. This is someone who has special training or experience or some specific skill or knowledge in a relevant area and who is allowed to offer an opinion as testimony in court. And I know any of you who have watched any type of court drama or any type of court proceedings have seen expert witnesses. Now, you can have expert witnesses that the defense calls versus prosecution in a case, and their expert opinions will vary. But an expert witness is one who's called on because he or she has specific training or experience or specific knowledge in a particular area that's relevant to the court proceedings. A felony, a very serious crime, such as murder or robbery. This is a felony. The Good Samaritan Law. The Good Samaritan Law is a legal doctrine designed to protect those who stop and render aid in an emergency situation. The laws generally provide immunity for specified persons from a civil suit arising out of the care rendered at the scene of emergency, provided that the one rendering the assistance has not done so in a grossly negligent manner. Okay, let's speak English here. I've just shown you I can read that. Now let's speak English. If someone who is a healthcare provider stops, they're obligated to stop and to render aid at the scene of an accident. The Good Samaritan Law says, okay, if you render aid, then the person to whom that aid is being given can't turn around later and then sue you for the aid you gave, unless you were negligent. So it has to be proven that you actually, if you are the one rendering the aid, did so in a manner that was actually negligent. But if you just stop out of the goodness of your heart and render aid, the Good Samaritan Law is a protection to say, if you did not just grossly negligently render that aid, then you're not going to be able to be sued by the person receiving the aid. A grand jury. A grand jury is a jury called to determine whether there is sufficient evidence that a crime has been committed in order to justify bringing a case to trial. It's not the jury before which the case is tried to determine guilt or innocence. I remember last time I did jury duty, just seems like just a few months ago, or that I was called for jury duty. There were going to be several juries to be picked, but also there was going to be a grand jury to be picked that day. And I'll never forget this. I got tickled at this, is that I remember when the O.J. Simpson trial was going on, and what was that guy's name that lived with him? He had long blonde hair, but or lived in part of the little room off the house or something, or the pool house. That's what it was. He had said something about a grand jury, and he said, I was very shocked when I had to testify in front of the grand jury, because I thought it was these people walking in robes and very distinguished, and it was just a bunch of old men in fishing hats. A grand jury is made up of just normal people. Its job is to determine if there's enough evidence that a crime was actually committed for it to even go to court. So once a grand jury rules that, yes, there is enough evidence, then a jury will be determined, but it won't be the same people. So that's the job of the grand jury. That guy's name was Cato. Now I remember. Cato Caitlin, because that was on TV, but I just remember that statement that he thought the grand jury was supposed to be all something very special, and it was just a bunch of old men with fishing hats. Okay, guardian. A person who has custody and control of another who is not capable of taking care of himself, such as a minor or someone who is incompetent in some way. A guardian will be named for that individual. Hearsay rule, we've talked about that. It's a rule of evidence that restricts the admissibility of evidence which is not the personal knowledge of the witness. Hearsay evidence is admissible under very strict rules. Remember when we talked about medical records are admissible as an exception to the hearsay rule, the business record exception to the hearsay rule. And that is a mouthful to say, but medical records are hearsay because they were recorded outside of court, but there is a business records exception to say that business records, even though they're hearsay, can be admissible as evidence in court because they're kept in the normal course of business and would normally reflect the truth of the occurrences. HIPAA, I just put this in here and did not elaborate. We've had much information on HIPAA, but even at this date and until the last day you get out, if you're asked, majority of you will put that the Health Insurance Portability and Accountability Act is HIPAA. It's not. It's HIPAA. It's HIPAA. All right. An incident report is a document prepared to record the events surrounding an action not normally occurring in the course of business. We've covered incident reports before, and we said how important it was that they're completed, but how very important it is that they are not put on the medical record as a permanent part of the record, an incident report. So, example, if a patient fell out of bed, or a patient fell, or even a visitor fell, something that happens outside of the norm, then an incident report, it is the policy that an incident report be generated, and then it is sent either to legal counsel, normally to the legal counsel of the hospital, incident report, but never is it to be put in the medical record. An indictment is a formal written accusation of a crime brought by a prosecuting attorney against one charged with criminal conduct. So if someone's indicted for a criminal act, then that is the formal written accusation brought by the prosecutor if someone is indicted for a crime. Informed consent. Informed consent, we've talked about that. Evidence that adequate information was given to an individual to enable him or her to make a decision to consent. Remember, we said there's a big difference between a patient just signing a consent form versus a patient being given informed consent. The risk, the benefits, the alternatives of a particular procedure, those types of things, that they were given adequate information to make a decision. It's not just putting a piece of paper in front of them and saying, here, sign this. An injunction. An injunction is a court order, so an order given by a judge requiring one to do or not to do something. So injunctions are given maybe to tell someone you cannot do this particular thing prior to this trial, or that you must do certain things prior to a trial. But an injunction usually keeps an individual from doing a certain thing prior to a trial, like taking money out of a bank account. Maybe it's a trial for a divorce or something like that, and an injunction would be given by the judge to say you don't shift around any funds or anything prior to this trial. Interrogatories are a list of questions sent from one party in a lawsuit to the other party to be answered. This is part of discovery, and one attorney will send to the other attorney a list of questions that for example, let's say the plaintiff's attorney sends to the defendant a list of questions that need to be answered. It's signed under oath that these answers are true. And so just a list of questions. Jurisdiction, that's just the term for the appropriate court to try cases based on geographic location. We talked about district courts, and there can be state courts, and there's federal courts, but the particular locale or area is known as the jurisdiction for that court. Liability, we've talked about that. A broad word for a legal obligation, responsibility, or debt. So to be held accountable or responsible for something is to be held liable. So that's liability. As opposed to libel, L-I-B-E-L. Libel is a false or malicious writing that's intended to defame or dishonor another person and is published so that somebody else sees it. And so remember, that's the written form as opposed to slander, which is the oral form of defamation. So libel, written, a malicious writing. A litigant, collectively the plaintiff or the defendant is a litigant. So just a party to a lawsuit, non-specific, doesn't say whether they're the suee or the suor, whether the one suing or being sued. Just litigant is just a catch-all for plaintiff or the defendant. Where litigation is a trial in court to determine legal issues, rights, and duties between the parties to the litigation. So, litigation is a trial. Living will, excuse me, we've already talked about that. We talked about advance directives, and we talked about power of attorney. Now, the living will, the other type, so it's a document that an individual makes where they express in advance of being incapacitated what they want to happen in the event that they have a terminal illness or they're in an irreversible coma. Malpractice, the term for professional negligence. As just general citizens, any of us can be negligent. We can do things that are negligent. If we do it as a professional, that's termed malpractice. There can be legal malpractice or medical malpractice, all different types, but it's professional negligence. Mature minor, we just talked about that when we were talking about emancipated minor. Mature minor, and I kind of am harping on this because it seems to be two definitions that sometimes students can't really get their heads around. That mature means someone who has not reached adulthood as defined by the state law, but who may be treated as adult just in certain circumstances. And again, perfect example is at 14 in the state of Alabama, a minor is considered mature to make medical treatment decisions. A misdemeanor, an unlawful act of less serious nature than a felony. We said the felony was a very serious crime. Usually a misdemeanor is punishable by a fine or by imprisonment of a term less than a year. We've talked about negligence. We just talked about malpractice and said it was professional negligence. Negligence is defined as the careless failure to act as an ordinary prudent person or action contrary to the conduct of a reasonable person. What would a normal, reasonable person do in certain circumstances? If someone does something that a normal, reasonable person wouldn't do under the circumstances, that can be defined as negligence. Non compos mentis means not of sound mind. Someone may be appointed a guardian if they are deemed by the court to be non compos mentis. Perjury means the willful act of giving false testimony under oath. So once someone's sworn in and under oath and then basically lies, that's determined to be perjury. Plaintiff, the party to a civil suit who brings the suit and seeks damages or other legal relief, so the one who sues. A potentially compensable event, an occurrence that places the hospital or healthcare institution at risk for a legal suit that would cost it money. So again, look at the term. This one seems to be a mouthful, but a potentially compensable event. An event that occurs that could potentially lead to compensation to another party. So that's a potentially compensable event. For example, if someone fell in the hospital, that is deemed at that time to be a potentially compensable event. Doesn't mean that it's written in stone that somebody's going to sue or that money's going to have to go out, but those kind of events are referred to as potentially compensable events. Precedent, we talked about that when we talked about common law or judge-made law. A court decision on a question of law that gives authority or direction on how to decide a similar question of law in a later case with similar facts. So we said the past will dictate the future, meaning past decisions are used to determine particular direction in a case if the facts of the case are similar. Discovery is always pretrial, so sometimes you see it written as pretrial discovery, the process used by both sides in a suit to collect information. It can be through interrogatories or depositions to just gather information to prepare for a trial. Prima facie, it's a fact, and that literally means at face value. So a fact presumed to be true unless disproved by some evidence to the contrary. A perfect example of this is when a individual takes an oath and is being questioned. And they say, please state your name. My name is John Doe. Well, unless there's really some doubt about that, that's taken at face value. In other words, everything that's said and done, you don't have to run out and prove. Well, if you are if you're testifying, then you have to, if you say your name's John Doe, then bring your birth certificate with you, those types of things. Now, it's at face value unless there's some reason or evidence to the contrary that something's not true. But some things are just taken at face value. Probate is the judicial proceeding which determines the existence and validity of a will. We talked about when we talked about the court systems, there's probate court. Wills will have to go through probate. Certain other circumstances or things are decided in the probate court, but that's what probate is. It generally deals with the existence and validity of wills. Promulgation, public announcement of binding rules and regulations by a government agency. So if there is a government agency that has rules and regulations, when those are put into effect, it is said to be, or when they are said to be promulgated on such and such a date. So that's promulgation. Quash, which is kind of a funny word, it just means to overthrow or make void. A perfect example of this is if a subpoena is issued for someone's records, say for their medical records, their attorney can go before the court to have that subpoena overthrown or void so that those records aren't released in court. And so to make or to overthrow is to quash, and we'll see that commonly when we're dealing with subpoenas. So the attorney had that subpoena, was successful in having that subpoena quashed. Real evidence is evidence furnished by tangible things such as weapons, bullets, equipment. So something that is tangible or can be seen or touched or held, that is determined to be real evidence. So in a court case, if someone had used a weapon, such as a gun, and is put in as evidence, that's determined to be real evidence. We can hold that gun in the hand and say this is the gun. That's real evidence. Okay, this term, res ipsa loquitur. And many times you'll hear people just say res ipsa, res ipsa. That literally means let the thing speak for itself, or the thing speaks for itself. It's a doctrine of law applicable to cases where the defendant had exclusive control of the thing which caused harm, and where the harm ordinarily could not have occurred without some type of negligent conduct. Okay, again, let's speak English, even though we're saying res ipsa loquitur. That's how you pronounce that term. Perfect example, and you need to understand this example in order to understand that term, res ipsa. Very good chance that you'd see that on an RHIT exam. You know, this is an example of what, and you would pick res ipsa loquitur. Here's the example. A patient has surgery, and then later on has some type of complication, and it's determined that there is a pair of hemostats in that patient. Let's say they had chest surgery. The patient had chest surgery. And it's discovered that the patient has that pair of hemostats inside his or her abdomen. The patient sues the doctor or the surgeon who did the surgery for complications because those hemostats were left in. Well, the patient can't testify and say, oh, I know that the doctor left those hemostats in me because the patient's knocked out. They didn't see what went on. But how did they get there? So if the patient had one surgery in the chest, had complications, and then on x-ray later on or through another surgery it was found out whether its hemostats were left in or sponge was left in, the only way it could have happened is because somebody left it there. And so that's what it means. Let the thing speak for itself. The patient can't prove it, but there's no other way that could have happened unless the surgeon who had exclusive control over those hemostats during that surgery had left them in there. And then there was subsequently harm done to the patient. And so that is a really good example when you're thinking about, okay, what does res ipsa loquitur mean? The thing speaks for itself, and that would be a good example. Okay, we talked about corporate negligence a minute ago. Then we have respondeat superior. Respondeat superior, meaning let the master answer. It's the legal doctrine that holds an employer responsible for the actions of its employees. And we said that corporate negligence is when the corporation is responsible for the actions of its independent contractors, or those who do work but are not direct employees. So they're the same thing, basically involving different types of, I'll say, employment. Either someone's employed or they are an independent contractor. And so if they're employees, it's respondeat superior, and literally means let the master answer. All right, slander. We talked about that. An oral statement made with the intent to dishonor or defame a person when made in the presence of a third person. And so slander is the oral form of defamation. Standard of care, term you'll hear time and time again. Those acts performed or omitted that an ordinary prudent person would have performed or omitted. It's a measure against which a defendant's conduct is compared. So, standard of care. What is the standard, whether it's in a particular area or a situation, for a particular circumstance? What would be the standard of care for caring for a patient with this particular diagnosis or carrying out this particular procedure? What is the standard? What would a normal individual do under those circumstances? But in healthcare, we talk about the standard of care. What is the standard? Did the care that was provided meet that standard? Stare decisis, we've already talked about that. Let the decision stand. That's what that means. It's the legal principle indicating courts should apply previous decisions to subsequent cases involving similar facts and questions, and we have talked about that one many times. Stark law is a federal statute that you may hear about. Doesn't necessarily have to do with any type of documentation, but it's a federal statute dealing with physician self-referral. And under this law, if a physician or a member of a physician's immediate family has a financial relationship with a health care entity, the physician may not make referrals to that entity for the furnishing of designated health services under the Medicare program. So you'll hear about this probably in different classes, but it's directly under the Medicare program. Just a physician can't refer individuals to for specific services when the physician stands to gain because they have a financial interest in that particular entity that's providing the services. Statute is just a written law. We've talked about that. It's a law that's passed by the legislature, voted on, and then it's written, and it's written in codes. Remember, codes can be on the state level, the federal level. Statute of limitations, we talked about that. It's a period of time established by law or written law or statute, and that should say statute, not by statute, that define the time period for bringing a lawsuit. And a lawsuit has to be brought, depending on the type of lawsuit, within a certain amount of time. Statutory law, just like a statute is a written law, statutory law is written law itself. A statute is actually a law, a written law. Subpoena, a written order compelling a person to appear and give testimony at a trial or other proceeding under penalty of failure. So a subpoena says, come to court to give testimony, whereas subpoena ducis tecum is come to court and bring the records with you. And that's not just limited to health care or medical records. It's anytime someone is told to, okay, come to court, show up at this time to give testimony, and bring these specific records with you. It can be in any type of record, or can be any type of record that's kept. A summons is a court order which directs a sheriff to notify the defendant in a civil suit that a suit has been filed and when and where to appear. A summons. Testimony, the oral statement of a witness given under oath at trial. The testimony. We've talked about tort or torts. These are a civil wrong. To do something wrong to somebody is to commit a tort. And then this next term always sounds funny to me. A tortfeasor. It's one who commits a tort. An old tortfeasor. That we said that tort is a wrong committed to someone else. Okay, finally, last two, the verdict is just the decision, the formal declaration of a jury's findings. That's the verdict in a trial. And a warrant. It's a judicial writ or order authorizing an officer to make a search, seizure, or arrest, or to execute a judgment. Most of the time, if we were, you've heard the term a warrant for someone's arrest. So it's an order authorizing an arrest. But a warrant can also be to be able to, you've heard of the term search warrant. That gives permission for the authorities to search, because we are protected as citizens against illegal search and seizure seizure of our property. In healthcare, you may see this, that a warrant is issued for a patient who is actually going to be arrested when they're released from the hospital, but also there can be a warrant that is released for medical records that gives the authority for someone, and it's usually for the government, to come in and actually look through medical records and then seize those medical records. And the only time that you'll usually hear of this is if there's some type of question of fraud, of Medicare fraud. And so instead of just viewing the records, they may get a warrant to come in, look through records, and take what they want to take, and they can walk out with the originals. And so I've heard of that happening. Not much, but that can happen, and that may be when at a time when you would be exposed to a warrant. So those are the definitions, or the most important definitions, in the legal glossary. And again, be sure and print your printable copy and review this, and make sure you understand the examples that I've given. And if you don't, be sure and contact me, so maybe that I can explain some things a little more clearly.